I like to cover legal tips for founders. I will try to condense my experience helping co-founders when they get into trouble later into 4 slides, condense it into the most important points. The first mistake that they tend to make is they don't get into signed agreements. So there are times when they use verbal understanding, verbal agreements. They also use WhatsApp messages to record what has been agreed. And finally, people like to use emails, thinking that emails are sufficient. Unfortunately, the court in Hong Kong and the courts in Singapore don't really regard WhatsApp messages or emails as being strong enough to protect your rights. So my first advice is to always have a signed agreement. It can be a one-page letter to be signed between you and the employee, or you and your co-founder, or you and your customer, your client, your investor. But please don't just use WhatsApp messages or having some verbal understanding. So common mistakes is that because he's your good friend, he's your classmate, you've known him for many years, or he's your relative, then you say, forget about doing an agreement. We don't need to do all that lawyer stuff. The problem is you're dealing with money and you're dealing with shares. And when things start to get a bit messy or confusing, the court is going to look at what was recorded. So it's very important to have agreements, no matter how short they are. And invariably, in all the cases that we see that there are big disputes, there isn't a proper agreement done. What is even worse is they might find someone who's legally trained, for example, someone who graduated from law school but hasn't practiced law, or someone who does property law or who does law or trust to advise them on contract law, and then mistakes are made. So that is also another mistake that can be done. Then when it comes to agreements with your co-founders, that is extremely important, especially when the company becomes successful. So you need to understand that problems don't happen when the company is starting up. When it's starting up, we're all best friends. We're all having dinners together and going to the trenches. The problem comes when the company becomes successful. When it becomes successful and when money comes in, lots of fame comes in, that's when there's going to be some slight misunderstanding. Common misunderstandings is who gets credit for the company's success. Initially, it was 50-50, or each of us does a certain role. But over time, someone may say, it was because of me that the company is successful. You just did the admin work. Or you just did the finance work. You didn't come up with the ideas. And they start quarreling. And it can start going downhill very, very fast, right? And then you have to resolve it using the courts. So what you need to do from the start is to have agreements to state clearly, right, the shares that you have and whose role it is. And maybe a simple line to say that parties agree that this is a joint effort and that no particular founder will take full credit or be dominant, right? So at the start, it's so easy to agree, so easy to sign. But once company becomes bigger, becomes successful, and other stakeholders come in, it's quite difficult. Okay, so that's the first guideline. What about agreements with other parties? Yes, the agreements with your customers are extremely important. The customers can give you trouble. For example, we have cases where they report you to the personal data breaches, and then your company gets in trouble. We have situations where some customers say that you have violated the data because they saw it appear on TikTok, for example, or YouTube. Then you get in trouble. So you do have to legally protect yourself from the customers before you go out and reach out to them. Otherwise, you're not authorized to fly. It's like if you don't have your seatbelt, don't drive. So the mistakes that founders make is they didn't know that problem could arise. They didn't know because no one told them. So they will go and try to go to the market and try to get customers. And then when the problem comes, it's a painful lesson to learn about that. The other agreements that you need to have is agreements with your suppliers. The first one could be your landlord, a simple thing as a landlord. And then later on, there will be, for example, your AI programmers who provide services to you. You need to make it very clear that You are paying them money, but they don't own the IP of your idea, and everything belongs to you. These are the basic things, and in the event of a dispute, how you're going to resolve it. The next thing that we see is choosing the wrong people, and I'm building up on Ben's earlier presentation about co-founders and all that. Choice of character is important. It's not really legal advice, but it is. We have seen cases where it was quite clear that there would be problems down the line. So when you choose your co-founders or your employees, there's only so much you can do to legally protect you with the contracts, which I talked about in the first slide. If you work with the wrong people, there are people who are troublemakers, and so you will need to get rid of them fast, or you need to terminate the relationship quite fast. If not, these people will give you problems. They have friends who are lawyers. They will consult them, and then they'll find an angle to give you some trouble. And they're quite mischievous. They do that to give you trouble so that you will give them money or give them shares, right? And so you find that your time should be better spent on your business and developing a product is trying to fight off this difficult person, okay? So there are some telltale signs about people. Look at their past, look at their history. How have they treated previous colleagues and previous founders, right? You also want to know whether the disparity of intelligence or wealth or power, right? If he is from a very rich background and you are not from a rich background, there is that disparity. So later on, he can engage lawyers. Also, his education level, which country he's from versus which country you are from. Even things like which race he is compared to what race you are. And, be alert to these things. Too often, the founders are focused on the business, the ideas, the sales, but you forgot that the biggest risk is internal. You have to fix the internal problems before you fix the external problems. So too often, you're looking externally when the thing that could sink your ship is right in your organization, right? So you have to have an open mind, and you have your radar both outside and inside. The other thing to note is that once things start to become difficult, you need to fix it quickly. I see some founders who, when there's a problem, they avoid. So they normally become incommunicado. They stop emailing each other because they don't like working with each other. And, these few months or 2 to 3 years, if you avoid each other and work around each other, causes the dispute to develop worse. So you need to face the person immediately and try to resolve it. There is a concept of mediation where you can get a third-party lawyer to come in the middle, and then you can structure some understanding, some agreement, and get it signed so that you prevent the problem from developing further. The third big mistake that founders make is ignoring regulatory and compliance risks. For example, I asked a question earlier when Andrew was presenting, and Andrew said he was not aware about how things could be protected, which was a genuine response. And that is precisely when you are in that particular business, you need to know. As the founder, you have to find out what the regulatory requirements are to enter that market and what you need to comply with to sell your product or your service in that market, in that country. You need to figure that out. And the mistakes the founders make is they approach a law firm, and the law firm gives them a quote, and it's quite expensive. And they said, no, forget it. We don't need the lawyers. And they go ahead and do it, thinking that we'll figure things out along the way. Now, when you're new and your product is small and you haven't gained traction, the regulators wouldn't bother. The problem is that when your business becomes successful, you're so busy popping champagne and giving interviews that you forget that, hey, you forgot about the legal piece, that you need to check this out. And that's when the problem happens. So things can happen. The regulators can shut down your website, stop your business. And we have seen cases where the company just becomes very unsuccessful because of that. So at some point in time, as a founder, when you get funds in, you should be slow to pay yourself salaries, but you should also look at getting at least one law firm from somewhere in the world to guide you on this regulatory and compliance risks. Don't forget about it. Don't think that it is expensive, because it is a necessary spend to prevent the government from coming after you. The last slide is also quite important. It is to protect your intellectual property. Very often when I meet a startup and I ask them whether they have registered the logo or the name, the usual answer is no, we have not. It is quite a beginner's mistake to think that just because I own a domain name, I own the brand. In the eyes of the intellectual property court, that is not true. The domain name is only something that you own. So it's good to register the name. So you have a particular name, it's good to register it in the country that you are operating in as a minimum, because there's a price to pay for each country. Then if you say, okay, my main country is Hong Kong, then you register in Hong Kong. Or if it's in China, you register in China. Then you can choose to do it in 2 or 3 countries. It's only about a few thousand Singapore dollars, right? About 20,000 Hong Kong dollars, 20 to 30,000 Hong Kong dollars. But that has to be done. Now, if you don't do it, and your competitor or your arch rival does it, they register that name just to piss you off, right? Then you have a big problem. It's gone. It's like a domain name. You were supposed to register the domain name, you forgot about it. Someone else took it. You can't get it back. You can't say, because I own the website or because I have a LinkedIn page with that logo, that definitely has to belong to me. So I'm going to go to court to challenge the other company because they took my intellectual property name. That can't be done. And this also later applies to the material on your website, the material on your app. That also needs to be protected. Initially, it looks like it's costly, takes a lot of time, but once you figure it out, you just can do it and replicate it. It becomes like a cut and paste job. So it's not too difficult. So the mistakes happen when you don't even do it. You don't even do anything. That means you do 0%, right? Once you consult a lawyer, or even if you ask ChatGPT what needs to be done, then you will avoid these mistakes. So that's all I have to share this evening. If there are any questions, please let me know.
Okay, and I have a couple questions for you because I started my career working in a large San Francisco law firm, and we were right there in Silicon Valley. One of our offices was. And so I have a few questions about things like your last slide where, okay, when your design team or your tech team creates something, that's really when you need to have those agreements that registered, because I've seen that happen. So anyway,